The Jacob Zuma Foundation says the former president has refused to be subject to a medical examination by doctors appointed by the NPA to determine if, in fact, he's fit enough to attend his trial. And that's at the Pietermaritzburg High Court.
But according to medico-legal practitioner Dr Herman Edeling, the NPA is well within its rights to assist on a medical exam by doctors that they have appointed.
Once the court and the other side receives that full report with opinions and reasons, they are at liberty to accept that, which will end the matter, or to still challenge it. So if the NPA accepts the credibility and validity of that report, and they go to the court and say, no, we accept this, the man is too sick to come to court, normally the judge would also accept that. But if the other side does not accept it, for whatever reason, and they're entitled to any reason, they are entitled to say, no, we would like our doctor to express an opinion. So any opinion evidence that is given by any expert is allowed to be countered by an expert appointed by the other side. Now, in a case like this, where the issue is the state of health of the accused person, it is essential for the expert of the other side to be able to view the person's medical records and to do a clinical examination of the person in order to be able to come to an independent opinion as to whether he is or isn't too sick to go to court.
All right, let's get you more insight on this now. Bring in legal journalist with News 24, Karyn Maughan, who joins us via our video link. Karyn, always great chatting to you. Thanks very much for making time for us on the AM report. So, as we've just heard there from Dr. Edeling, a second opinion is not the same as second guessing initial medical reports. And I'm only saying this because that, by and large, is the thrust of the pushback, at least from the Jacob Zuma Foundation.
Absolutely. And remember, of course, what needs to be stressed here is that the right of the NPA to appoint a doctor to do its own examination was in fact made in order by the Pietermaritzburg High Court. And I was watching the video hearing of it, a recording of it yesterday. And Judge Karyn was at pains to check with Advocate Dr who represents Jacob Zuma, whether he was, as he said, he had any difficulties with an order to the effect. And Dr asked him to read the wording of the proposed order and then said, no, that's fine. That he could understand under the provisions of the Criminal Procedure Act, which allow courts to satisfy themselves as to the state of health of an accused in a criminal case, that this was an appropriate thing to do. So we now have a circumstance where, it appears that if the former president makes good on what his foundation is saying, his stance is at this point, there are experts who are contending he may well face further accusations of contempt of court.
Yeah, that's exactly what I was actually going to ask you, but we'll unpack that a bit more a little bit later on. I'm hoping we can speak to what the Jacob Zuma Foundation is contending by and large, at least from what I've heard. Part of what Maughan is saying in defense yesterday is that there's kind of this exceptionalizing of Jacob Zuma's matter, right? He's calling it the Jacob Zuma laws, I think, if I'm paraphrasing correctly. Has the NPA, let me ask it this way, what do we know about the reasons given by the NPA about why they want to have their doctors examine the former president?
Well, we know from the initial hearing that happened that when the initial evidence was put forward by Jacob Zuma's lawyer at the time, basically stating that, he had a serious medical condition. He included letters from the military doctors, Brigadier Mdutwa, who was responsible for his health, the head of the military services, basically saying that he had a serious condition that had been untreated for 18 months, but now required emergency attention, and that this could essentially take 6 months of treatment. That the state said under oath and in the court hearing that they were simply dissatisfied with that evidence, that they wanted more substantiation for it. Now, we know in the interim, after a 7-day delay, that the doctors for the former president have submitted a confidential report. But the state is extremely tight-lipped about its attitude to this. Its stance during the hearing as was actually articulated by Advocate Mpofu himself, was simply that, in order for them to be able to cross-examine Jacob Zuma's doctors, if it comes to that, if he does make a substantive application for postponement, they needed to be able to rely on their own expert to ensure that, they had all the facts at their disposal. So their stance seems to be that this is an ordinary thing that happens. These kind of applications are typically brought in camera. I am aware of a few other matters in which such applications have been brought in camera. And they're simply, they're not going on record on any of this, but I think their contention has been, well, this is part of our way of ensuring that there's public trust and faith in the ultimate decision that is made with regard to a postponement.
How worried should we be that this could add yet another layer that could contribute to even more delays in this case finally going ahead? You've already mentioned that some experts are suggesting if the former president really puts his foot down, he could be found to be in contempt of court, and that may lead us to another case within a case.
I think, having spoken to Maughan yesterday, he made it very clear that if the former president regarded, if there was a decision ultimately that he would have to be forced to comply and submit himself to this examination, which Mr. Manyi suggested would essentially violate his rights to consent, his rights to dignity, and his rights under the Constitution to bodily integrity, he would consider possible legal action. So we then have a scenario where we have an application against, to challenge any potential order that he be subjected to examination by an NPA doctor in the context of an application for potential postponement based on a health condition, in the context of a special plea, which is about arguing that the NPA doesn't have title to prosecute him. And in the midst of that, a potential application for witnesses to testify. We're talking about 3 or 4 different applications, all of which can be appealed, all of which can be challenged, and all of which could take years to resolve. So I think at this point, the prospect of a now 79-year-old Jacob Zuma ever actually standing trial is looking increasingly slim, if not impossible.
And many might suggest that was always the strategy to begin with. Lastly, Karyn, it almost feels like the ball is now in the NPA's court if the former president has on record refused to be examined by NPA-appointed doctors. How do you imagine the next step looking?
Well, I think what will happen, and obviously we have no sense at this point of how much of this application is actually going to be open to the public, but ultimately I think that they will turn to the judge and say, this was made in order of court. You need to make it plain to the other side that, this needs to happen. And if it doesn't, obviously they're going to have to consider their options. But certainly in the context, if indeed they don't agree with this report and they do believe that there are doubts in their own mind that they need a doctor, their own doctor, to examine him, they will have to then possibly, look at enforcing that and face the very real possibility at this point that the former president will then take legal action as a consequence of that.
Sure. Certainly getting a sense that we are nowhere near the end. Karyn Maughan, thanks very much indeed. Always great getting your insights. Karyn Maughan is a legal journalist with News 24.